I do not wish to be represented by a attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barricay was an unlawful arrest.
All right,
for
well, we're not.
Failure to appear for a court date could result in a bench warrant for the individual's arrest. You understand that?
Well, I don't understand in the sense I do not stand under it, and I object to that because that violate my right against sovereignty.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
All right, I got it. All right, that you failed the state of action upon which the court can grant relief. This case and the complaint in this matter be dismissed.
In that sense, I'm going to ask that that the court clerk make a copy and send it to them, so I don't have to spend money to make the copies, which I think violates my right to access to the courts. And as the U.S. Supreme Court said, the Murdoch versus Pennsylvania.
All right, and that's what I'm going to call now, because it looks like it's between Mr. DeBus and Mr. Cochran. Well, I can't call, Mr. DeBus, you want to start your video? Okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBus, with Jared Regier for the state, Mr. DeBus in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBus led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand and would need the benefit, or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. DeBus, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the state of Kansas Corporation.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBoos, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me you apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
One moment, Your Honor. Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issuable trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay.
And Your Honor, I would note that pursuant to the information filed with the court in August, this case does appear to include 3 counts, 2 Class Bs, and an unclassified non-person misdemeanor. While it would appear that in this particular instance, subsection 2, pursuant to KSA 216602, quote, for purposes of sentencing, the following classes of misdemeanors and the punishment and the terms of confinement associated for each class are established. Class B, the sentence for which shall be a definite term of confinement in the county jail, which shall be fixed by the court and shall not exceed 6 months. So given that, my understanding is that neither a plea nor sentencing recommendations have been submitted to the court in this matter, it would appear that at least the issue raised by standby counsel is somewhat academic.
So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or I mean consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people under granted to us in restriction of government entities for the people itself. I comprehend that I have my right to jury trial, which I thank Mr. Patterson in his brief support towards this and towards me, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right, well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's the thing, Mr. DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you? And do you not want to have his legal assistance to let him represent you?
Psychologist Leon Festinger described cognitive dissonance when someone wants two conflicting things at once. Here, the sovereign citizen defendant wants total control without legal counsel, but also needs legal help when procedure gets complex. That feels independent in the moment, but in court it creates delay, weak arguments, and leverage for the prosecution.
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barricade was an unlawful arrest.
All right.
For
Well, we're not going on
22-2401.
We're not going down that path right now, sir. We're not going down that path right now. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which they're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be September 30th, 2024. Do you have any objections to that?
No objections. Let me write those dates down. You said September what?
The pretrial is September 30th, 2024 at 9 a.m. And the jury trial starts at 9 a.m. October 2nd and 3rd.
Both of those dates?
Both of those dates.
Okay. I would like to point out that the bond and bail I made on this arrest is an unlawful bond, considering that the arrest was unlawful itself.
Looks like Judge Crum set your bond on August 18th, 2023 at $2,500 cash or surety, and that will be maintained so long as, sir, you appear at every date and time you're required. Anything else, Mr. Regier, we need to take up on this matter?
Your Honor, if If the court is granting the defendant's request for continuance, I would respectfully have it noted for the record that this case at the next hearing will be over a year in age, as I understand it. So the state is not in favor of this continuance. So I would respectfully have that noted. Additionally, my understanding is that a motion in limine was filed by my office. And if the court is saying this matter for both pretrial and jury trial, I would respectfully reserve my rights pursuant to the stay and have the motion in limine be addressed at the pretrial hearing.
That the objection of the state to the continuance is noted. And yeah, we can take the motion in limine up.
Your Honor, if I may be heard briefly.
Yes, Mr. Patterson, please.
The motion that counsel is talking about was emailed to me. I'm not the attorney of record, so I have not accepted service. I sent an email back to counsel, and I did provide Mr. DeBus's address that I had seen in the court system that they can directly mail that to, and I would just ask that that be mailed to Mr. DeBus for service.
And Your Honor, I am showing in my file an affidavit of service by first-class mail, and which would appear to include a mailing date of at the end of last week.
All right. Very well then. And if there's nothing further, did you get that, Mr. DeBuse? Did you get the copy of the motion he's in reference to?
To what mailing address did you send it to, Mr. Revere?
Well, just tell me if you got it or not, sir. Did you?
No, I did not.
Okay. All right.
And Your Honor, one last thing. I did email to court and counsel the copy of the case law about constitutional right to a jury trial.
Thank you, Mr. Patterson. I appreciate that. And Mr. Regier, he wants to know what you sent that to.
I'm afraid I do not understand the court's inquiry.
He wanted to know what the defendant asked, what address you mailed the motion to.
Your Honor, the affidavit of service I have in the file appears to be at an Andover, Kansas address.
Okay. Are you still in Andover, sir?
I'm in Wichita.
All right. Well, you have to keep the court informed of your address, or you're going to maybe miss more important documents. So can you send your current address to Mr. Patterson and Mr. Regier in the chat here without having to say it live over the internet?
I'm not for sure the address is going.
I'm sending in the mailing address now.
Okay.
And Mr. Patterson, do you have any legal authority that suggests that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. I keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas. Okay, so that takes care of Mr. DeBuse's case. You are excused, sir.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on this Zoom? Say something if you hear it this time.
Yes, Your Honor. Javar Grayson representing myself.
All right, thank you, Mr. Grayson. Good morning to you. as
Good morning.
well. So, I see that there is let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You
Okay.
submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You telling me that the court doesn't have jurisdiction, and you're not submitting to the jurisdiction of the court. And why are you filing something in this court if you believe the court doesn't have jurisdiction? You filed
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who's representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
Well, certainly. Let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, straight that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss and will answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, no factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is a some type of traffic ticket. I started off Brian Ambrosius stopping me, and I believe I have the right to travel. It started with that, and I do understand the default judgment. What do you that you are saying, and what is pertaining to? We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiff, and it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
All right, I got it. All right, that you failed the state of action upon which the court can grant relief. This case and the complaint in this matter will be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same. But yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides. I wish you well.
Thank you, Your Honor. Well, does the court be entering the order, or do you want me to submit it?
If you would submit it, Mr. Michaels, that would be helpful. I will send you a chat to address where you want to send that. And that would be helpful. So I'm chatting that to you now, sir.
All right. Thank you. Thank you, Your Honor.
Call case 23S00425, People State of Michigan v. Eric Martin. Allegations are that on July 11, 2023, Ypsilanti Township, Washington County, State of Michigan, on I-94 at or near Michigan Avenue, you did operate a motor vehicle at a time your driver's license was suspended or revoked. A misdemeanor carrying a maximum penalty of convicted of up to 93 days in jail, a $500 fine plus court costs, or both. Do you understand that?
Oh, I do not understand in the sense that I do not stand under the charges.
Yep. Count 2 alleges that on the same date, time, location, you did operate a motor vehicle at a time you did not have in full force in effect. Insurance is required by state law. Again, a misdemeanor carrying a maximum penalty of convicted of up to 1 year in jail, a $500 fine, plus court costs, or both. And the third count alleges that on the same date, time, location, you did operate an unregistered motor vehicle. A misdemeanor carrying a maximum penalty of convicted of up to 90 days in jail, a $500 fine, plus court costs, or both. These are misdemeanor charges. You have certain basic rights. You have the right to remain silent and say on the record Canada would be using it to a trial. Court's entered not guilty pleas as all counts. The public defender will address bond in these matters.
Assistant Public Defender Lemmy Saab appearing with and on behalf of Mr. Martin, requesting a PR bond this morning, Your Honor.
Thank you.
Yeah.
I object to any representation by any attorney, as I invoke my right to Republican form of government and Republican laws under Article 4, Section 4 of the U.S. Constitution. Meaning
my phone just kicked on to where I can hear.
Hey, hang on, Mr. Mayor. I'll be with you in a minute. Okay. Of course, no to the objection. The public defender is excused from proceeding further.
And that's just, yeah, not make it clear, not just as to them, nothing with them, just them specifically. I'm saying any and all attorneys, because I do not give up my right to be sovereign as one of the people, as the U.S. Supreme Court said I have as one of the people, the right to Republican form of government and to be sovereign. So that's why I say that.
Thank you.
Yep.
All right, Mr. Martin, we will set a pretrial hearing September the 14th at 9 a.m. via Zoom.
Is it so fast? Let me write. September 14th is September 14th. What time?
9 a.m.
9 a.m. And that's what's the title of that proceeding?
That'll be a pretrial hearing.
All right.
Prosecutor will be present for that hearing. We have any future filings you make with court, make sure you copy the prosecutor on. We have forwarded these for you as a courtesy, but if you make any future filings with court, including the ones you've already filed here, or in addition to the ones you've already filed, make sure you send a copy to the prosecuting attorney's office. Their address will be on the notice we'll send you, okay?
Okay, I have another objection here. I also object to a challenge of jurisdiction in this case against me as a living man.
You can make that motion in writing. Again, any motions made in writing be filed with the court and served on the prosecuting attorney's office. Okay.
Okay.
All right. Did you receive a text message to remind you about today's court date?
Did I receive a text message for what?
To remind you of today's court date.
Of today's court date? Yes, I did.
Okay. Just want to make sure you're receiving those, so you're getting that notice. We'll mail them to your address on record here too as well. Okay.
Okay. Yeah.
All right. You're all set for today, Mr. Martin. Again, September 14th, 9 a.m. Failure to appear for a court date could result in a bench warrant for the individual's arrest. You understand that?
All right. Well, I don't understand in the sense I do not stand under it, and I object to that because that violate my right against sovereignty and Article 4, Section 4, Republican form of government, and
all right. Your objections noted.
And there's many other reasons too why I objected, because there's no jurisdiction here under many other reasons.
Well, as courts operate, you will need to file any objections in writing. I've instructed you on how to do that. So if you want to submit those objections, just write it up and make sure you send a copy to the court and to the prosecuting attorney's office so they're prepared to address that at the next court date. Okay.
Yeah. So okay. Well, one objection I kind of have with the prosecutor in the sense of. I will if I must under threat and duress. Oh, that's another thing I was going to mention. Now, I'm appearing here by special appearance, not a general appearance. And this is through threat and duress of, the rest and all that, the normal procedure that courts follow. So I just want to make that clear. I'm not really consenting to, appearing here today. I'm not consenting, for future references to be held under the jurisdiction of the court. and all that. And it's one of the legal authorities I use for this is the Michigan Constitution and the U.S. Constitution under the 13th Amendment right against slavery and to not be subject to involuntary servitude. That's one of the legal authorities I rely on to be subject to any arrest for the bench warrant, like you mentioned, or anything else that's, against my will. And just want to mention that.
You've made your record on that point.
Okay. But now what was I say about the copies of the prosecutor? Now, I will if I must under threat and duress, but see, that costs money. And I shouldn't have to spend no money for my access to the court, such as by making copies. That just costs more money for me to make the copies. So in that sense, I'm going to ask that if that the court clerk make a copy and send it to them, so I don't have to spend money to make the copies, which I think violates my right of access to the courts. And as the U.S. Supreme Court said, was it Murdoch versus Pennsylvania? I think that was one of the cases I cite dealing with my other arguments. We don't have to spend money for the exercise of a right.
But you do. You would have to. Can I address that for you, Ms. Martin? If I may, I'll address that for you. Okay.
Go ahead.
Okay. So, if there's a finding of indigency and you need to fill out a form indicating that you're indigent, so you can find that form on our website. If you file that form and there's a finding of indigency, that's easy enough for me to say, then we consider that at that point in time. Okay.
Well, I'm saying in addition, not just, I know the normal indigency is normally a thing, but I'm saying regardless of the aspect, just simply because it's a right of access to the courts, it's not just limited to indigency. It's just period. I shouldn't, don't have to pay money for the exercise of right, period, regardless whether I'm indigent or not,
I hear you, but that's a process that we have under the court rules.
Right.
If you want to challenge the court rules as they are, there's a process for that, but we have to operate with what we have to operate with right now. Okay.
Well, the court rules is, like I said, just once again, and that's the final thing to say about it is under Murdoch versus Pennsylvania, U.S. Supreme Court, and I got the volume and page and recited to already one of the papers, in general, just the right of access to, to pay money for the right, to exercise our constitutional right, no matter what constitutional right it is, you can't be charged a fee, period. So
you made a record on that point. Like I said, there's a process for it right now that exists. If you want to challenge the processes, you'd have to, to do that otherwise. But so again, your next court date will be September the 14th, and we're all set for today, Mr. Martin. You have a good day. Thank you for coming in today.
Yeah, you too. Yep, bye.
Across all three hearings, the same pattern keeps repeating. Each defendant tries to fight the system by rejecting the system's language. They challenge jurisdiction, claim special appearance, invoke the right to travel, or separate themselves from the legal name on the case. Those arguments can sound powerful because they promise escape from rules without paying the cost of proving innocence. But courtrooms run on procedure, not slogans. Judges are listening for motions, evidence, deadlines, service, and legally recognized claims. When someone answers procedure with ideology, the court usually treats it as non-responsive. That means the real issues keep moving forward while the defendant spends time arguing side roads. In Kansas, asking for more time may feel like gaining ground, but continuances also extend stress. Keep bond conditions alive and give the state more time to prepare. In Michigan civil court, filing a case without a recognized legal cause leads to dismissal, no matter how strongly the person believes the principle behind it. In the criminal case, repeated objections without written motions change nothing and can leave the defendant standing in the same place at the next hearing. This is why sovereign citizen strategies often fail quietly instead of dramatically. There is rarely one explosive moment. It is usually a series of small procedural losses, missed focus, weak filings, ignored warnings, and credibility erosion. The deeper lesson is simple. In court, refusing the map does not stop the road. It usually just makes the trip longer. And the next hearing often matters more than the last one,